Hey guys, it's Professor Hips, and this is going to be a lecture overview of the judicial branch in the hopes that if we don't get to the material in class, that you have a good overview of the material. You also have the textbook and any of the supplemental videos that are in Georgia View that can help you to navigate this particular material. So the judicial branch originates in Article 3, which is a departure from Articles 1 and 2, which give pretty detailed overviews about how both the legislative and executive branches should work. Article 3 is a little bit more vague in that it only really creates a singular court, which is the Supreme Court. All of the other courts are created at basically the sort of decisions of Congress to create other courts to help the Supreme Court carry out its duties. Well, that manifested itself by the Supreme Court being constitutionally mandated. Federal district courts, or the lowest level of courts, were created through the Judiciary Act of 1789. And in 1891, we created the U.S. Court of Appeals to act as a federal sort of appellate level court. We'll talk about what that means here in a moment. So in the United States, we have a dual court system, meaning that we have sort of a mirrored system on the federal and state level, and we also have a dual sort of system of law, which is criminal versus civil law. Criminal cases involve the government prosecuting an individual for breaking public laws. This can result in potential jail time where guilt needs to be proven beyond a reasonable doubt. Civil cases resolve disputes between private parties, so individuals versus individual or individual versus a business. And the aim is almost always to compensate victims, usually through money, and the standard of evidence or the burden of proof is lower. In a criminal case, the parties involved are typically the state versus the defendant, so Georgia versus Hips. Whereas a civil case is private party versus private party. So Hips versus Whites would be an example of two individuals kind of suing each other. Criminal cases are initiated by the government, while civil cases are brought by an individual. Criminal law punishes offenses against society. So any crime that makes society at large less safe is often a criminal offense. Civil law compensates victims for wrongful acts. The burden of proof, which we'll get into a little bit more later, is much higher for criminal cases. Criminal cases typically require beyond a reasonable doubt, which is the highest standard of proof that you have to meet, while civil cases require what's called a preponderance of the evidence, or basically it's more likely than not that the person is to blame for the thing they're being accused of. Criminal penalties include jail time, prison, fines, or even in the most extreme cases, death, while civil remedies are almost always monetary. Finally, criminal defendants have significantly more constitutionally protected rights. They have a protection against self-incrimination, they have a right to counsel, they have a right to a jury trial, where civil litigants or people who are bringing civil suits have far less constitutionally protected rights. Now, although the state courts are important, we're going to focus on federal level courts in this particular class. So we want to talk a little bit about federal jurisdiction. Jurisdiction is simply the authority of courts to hear certain cases, right? So federal courts are what we call courts of limited jurisdiction. They're authorized by the United States Constitution and other federal laws to hear certain types of cases. Primarily, they handle cases involving federal laws, the U.S. Constitution, treaties, cases where the U.S. government is a party, meaning someone suing the U.S. government, or controversies between citizens of different states. So let's say someone from Georgia is suing someone from Tennessee. There are some questions there about do we follow Tennessee law or Georgia law? So oftentimes these are also settled in federal court. There are some core types of federal jurisdiction. So there's what we call diversity jurisdiction. That's what I just mentioned, these sort of disputes between citizens from different states. This can also occur when there is a dispute between a U.S. citizen and a citizen of another country. So these diversity jurisdictions happen when the conflict is between two parties where the laws governing them are not necessarily the same. There are also what we call federal question jurisdictions, where these are cases that deal with sort of U.S. constitutional questions or those treaty-based questions. There's also cases that involve the United States where the federal government is a party. There's admiralty and maritime law. So these are cases that happen on the seas, and there are some different laws and statutes that govern what happens in international waters. And then there are cases that are affecting foreign diplomats. So what would happen if a diplomat of another country was accused of committing a crime in the United States? When it comes to the types of authority or the types of jurisdictions that exist, there's original jurisdiction, which is the authority of a court to hear a case for the first time. These are also, if you want to think about it a little bit more simply, it's just guilt or innocence. These courts determine, did you do it or did you not do it? There's appellate jurisdiction, which is the power of the court to review a decision of the lower courts. There's exclusive jurisdiction, which are cases that can only be heard in federal court, such as bankruptcy, patent law, copyright cases. And finally, concurrent jurisdiction, or cases that can be heard in either federal or state courts, or where you have both the ability to have original jurisdiction and appellate jurisdiction. All right, so let's talk about those levels of courts that exist in the federal system. We'll start with that lowest level of court, which are U.S. district courts. These are the general trial courts. There are 94 districts nationwide that handle both civil and criminal cases. They have original jurisdiction. And so these courts conduct trials, hear witness testimony, use juries, and they serve as the first line of federal litigation. So as I mentioned, there are 94 of these districts. There's one in every state, at least one in every state, plus DC has one, Puerto Rico has one, and then the territories of the US have one. These judges are appointed for life by the president and confirmed by the Senate. They are often assisted by what we call magistrate judges, who handle sort of the lower level cases. District courts handle cases involving sort of violations of federal law, the Constitution, or treaties, disputes between citizens of different states, and cases where the U.S. is a party to the case. Each district court also has a U.S. bankruptcy court, and these courts hear testimony, accept evidence, hold trials, and they could be decided by either a jury or a judge. If they are heard by just the judge, it's known as a bench trial. The next level of courts are appellate courts. Appellate courts are found at both the state and federal levels, and they review decisions from lower trial courts to ensure legal accuracy and procedural fairness. Rather than retrying a case or hearing new evidence, panels of judges, referred to as en banc, usually panels of 3, review the existing record for legal errors, such as mistakes in applying the law, or if the court feels that a judge abused their discretionary powers. And so their primary role is to correct legal errors that have been made in the lower courts. This means they have the power to either affirm or basically confirm the decision of a lower court, reverse the decision of a lower court, or remand or send back the case for further action. So sometimes the court will say, we're not saying that this is right or wrong, rather we want you to go back and review the case again and make sure that you really did the things that you're supposed to do. Finally, at the highest level, we have the U.S. Supreme Court. And the U.S. Supreme Court is unique in that it decides the types of cases that it gets to hear. So cases that are reviewed by the Supreme Court are often cases that deal primarily with either large constitutional questions or things that are going to impact large percentages of the country. In order for a case to be heard by the Supreme Court, it has to adhere to the rule of four, meaning 4 of the 9 Supreme Court justices have to agree to hear the case. All right, there are multiple ways that cases can be presented to the court, but they almost always either come from a lower court, where the lower court has asked the Supreme Court to review it, or the Supreme Court could issue what's called a writ of certiorari, which is a request for the information regarding a case because the Supreme Court wants to hear it. The current Supreme Court is made up of 6 conservative justices and 3 liberal justices. Now, it may seem odd that the court is partisan. Like, why would the Supreme Court, the highest court in the land, be concerned about Republican or Democrat? Shouldn't they just apply the law in the way that it's supposed to? Well, in a perfect world, that's what would happen. But the reality is that the way that judges interpret laws is often affected by their overall worldview and their belief about how the law should and does operate. The sort of process of nominating Supreme Court justices is a more controversial one than it's been in the past. And this really was exacerbated or made worse with the death of Antonin Scalia in February of 2016. So Obama is president. There's about a year roughly left in his presidency. And when Antonin Scalia dies, there is a vacancy on the court. Right? Republicans are concerned because Scalia was one of the most conservative justices, and it was very likely that President Obama was going to appoint a more liberal justice to replace him. At the time, that would have tilted the court 5-4 liberal to conservative. So when Scalia was found dead at his ranch in Texas, his death really sparked this huge political question. So within hours of the news of his passing, a battle sort of erupts. So at the time, Republicans are in control of the Senate. Senate Majority Leader Mitch McConnell, who's a Republican from Kentucky, announces that we're not going to fill the vacancy. We shouldn't fill a vacancy in the last year of a president's term because the people should get to vote and pick the new president, and that president should get to decide. Democrats are furious. All right. Obama says, well, it's my constitutional duty to nominate someone. And he tells the Senate, your job is to interview and give the nominee a fair hearing or a vote. Republicans, who control the Senate, follow through on their promise, and they refuse to hold a hearing for Obama's nominee, a guy named Merrick Garland. As a result, they did not confirm a Supreme Court justice the entire last year of Obama's presidency. Trump wins the 2016 election. He appoints Neil Gorsuch to that position. Things get even more partisan when in September of 2020, Ruth Bader Ginsburg, a liberal stalwart on the court, dies 46 days before the presidential election. So Ruth Bader Ginsburg passes away 46 days before the presidential election. Republicans say, well, we got to fill this immediately. Democrats are, again, furious, arguing, well, you just said in 2016 we couldn't fill a Supreme Court vacancy a full year before the end of Obama's term. Now you're saying 46 days before Joe Biden is sworn in, or I'm sorry, before the election occurs, it's okay to confirm a Supreme Court justice. And Republicans say yes, and in the fastest confirmation in Supreme Court history, they replace Ruth Bader Ginsburg, a liberal stalwart of the court, with Amy Coney Barrett, a Republican nominee who at the time had not been a federal judge. And so Democrats are mad, saying that basically Republicans are hypocrites. They violated their own principle. and thus the process has become even more contentious than it used to be. All right, the long-term effect is now we have a majority of the court who were appointed by presidents who did not win the popular vote. Remember, George Bush didn't win the popular vote in 2004. Donald Trump didn't win the popular vote in 2016. And both of those presidents have appointed 5 of the 9 Supreme Court justices that are currently on the bench. And so there was a conversation about how judicial power should work. Is that an appropriate way for this thing to work? It's also important to note that Justices Alito and Justice Thomas, who are both older conservative members of the court, are likely to retire in the next several years. In the event that both of them retired before the end of President Trump's term, Trump would have appointed 5 of the 9 Supreme Court justices on the Supreme Court. There are some who argue that's too many justices for any president to appoint to the court. And if they are replaced by 2 younger conservative members of the court will be conservative ostensibly for the next 30, 40, or 50 years. Which Democrats argue is unfair. So that partisan conversation, Republicans sort of being able to wield that power in ways that are very strong and full-throated, and Democrats who are upset about that, but likely would wield power in a similar way if they had political power during that time, has caused a much more partisan bent to the conversation about Supreme Court justices. Now, once a case is at the Supreme Court, the process by which the sort of Supreme Court hears a case or reviews a case is relatively well known, although we don't know all of the details of how that works. But what we do know is that basically the way that it kind of works is that parties submit these legal arguments known as briefs. They're often accompanied by amicus briefs. Amicus briefs are a Latin term that just means friend of the court. So people who have a vested interest in the outcome tend to write letters on behalf of either party. We then know that there are oral arguments, about 30 minutes of oral arguments per side that are made to the court. The justices are able to sort of ask questions and inquire more deeply. And then they move to the sort of justices meeting. Now, we don't have a lot of information about how this process works because it happens behind closed doors. And for the most part, justices are pretty tight-lipped about how that process works. But we do know that they vote according to seniority, with the Chief Justice voting last. The reason for that is, the thought is, if there are 4-4 ties, the Chief Justice, which is largely sort of acknowledged as the most knowledgeable member of the court, would always be the tie-breaking vote. All right. Once they have voted, we then have to sort of think about how their decision affects what we call precedent and stare decisis. And so the thought here is that when judges make decisions, they are constrained by the Constitution, laws, and what we call precedent from previous judicial decisions, which are judicial procedures and processes that have been decided by the court in the past. And so most judges follow what we call stare decisis, which is Latin for leave it alone. Basically, as a practical matter of public policy, if precedents were routinely overturned, the law would effectively not be fixed and the judicial workload would be multiplied endlessly, right? Like if every time a case got reviewed, it flipped and the decision flipped, the court would just constantly be reviewing the same cases over and over and over again. And so we want there to be stability in the law. We want to be able to almost predict what the court will do based on historical precedent. Second, the credibility of judges as impartial interpreters of the law would be damaged if there was sort of an understanding amongst the people that the law and what it means is totally dependent on the preferences of a single judge, on a judge's interpretation on any given day. So the process that we have is one where judges, for the most part, have been hesitant to overturn precedent because they understand that if we start undoing all the decisions made in the past, no one's going to have faith in the decision-making process. It also, I think, is an important conversation point of how presidents then talk about the courts are really important, right? Like Obama during a State of the Union sort of criticizing the Supreme Court for their decision in Citizens United was a significant turning point because for the most part, presidents tried to avoid openly critiquing the court. Now, I would argue, having watched that particular State of the Union myself, it was a pretty mild criticism of the court, but was a public criticism nonetheless. Donald Trump has engaged in much more full-throated criticisms of the court, acknowledging that he believes the decision was wrong, or sort of publicly encouraging justices he has appointed to rule in his favor. And again, while it's not surprising, like presidents want the courts to behave in particular ways, those public sorts of displays about how the court work really have sort of the potential to influence the decision-making process of the court in ways that undermine public faith in the court's ability to make impartial decisions. So once they have voted and decide, they write opinions. There are a couple types of opinions that are important. So first, you have a majority opinion. So this is written by a majority of the justices in a particular decision. It's usually written by the most senior justice. If the Chief Justice is on the side of the majority, he'll often write the case. If not, then usually the longest tenured member is able to decide. There are concurring opinions where a justice agrees with the overall decision but disagrees with the logic. So let's say you're hearing a case about discrimination and you believe it's a civil rights violation and somebody else believes it's a due process violation. So both of you agree that it is a violation, but you disagree on the reasoning behind it. So you would write what's known as a concurring opinion. A dissenting opinion is the opinion of those who disagreed with the outcome of the decision. Dissenting opinions are particularly important in close decisions. So if a case is a 5-4 case, for example, the dissenting opinion is really important because it basically lays out the roadmap for challenging that case in the future. This is a wonderful video from Vox about sort of the Supreme Court process and how that process works. I urge you to watch that. This is another great TED-Ed video that lays out the process by which Supreme Court justices are appointed. I gave you a little overview of sort of some of the controversies over the last decade surrounding appointments in the Supreme Court, but this does a wonderful job of kind of highlighting the process by which Supreme Court justices are appointed and the considerations that a president has to make as they make those decisions. All right, let's talk about the powers of the court for a few moments. So the most significant power that the court has is the power of judicial review. Judicial review, simply put, is the power of the court to declare the actions of any other branch of government unconstitutional. It stems from a case, Marbury versus Madison. Marbury versus Madison is a landmark Supreme Court case where basically the court established a principle that affirmed its power to declare acts of Congress unconstitutional. It stemmed from a case where William Marbury sued the Secretary of State, James Madison, for failing to deliver his judicial commission, or a paper basically saying he was allowed to be a judge. This led Chief Justice John Marshall to rule that while Marbury was entitled to forced delivery, the court lacked the authority because the law enabling that action was unconstitutional. So basically, it asserted the Supreme Court's authority to interpret the Constitution and strike down federal laws that conflicted with it. This is a great overview from the History Channel on Marbury versus Madison, and does a good job laying out why judicial review is so important. But judicial review stems from something known as syllogistic logic. Syllogistic logic is a philosophical concept, and it centers around if-then statements. So if A is true and if B is true, then C is true. So the argument they made was, if the Constitution is law and if the courts interpret the law, then the courts interpret the Constitution. And if the Constitution is the supreme law of the land and a law then conflicts with the Constitution, that law is unconstitutional. Those two things taken together created the power of judicial review. All right, let's talk about the role of the courts, and then we'll kind of finish up by talking about our trial process. So when it comes to what the courts actually do, they have two main functions: law interpretation and dispute resolution. Law interpretation is all about defining the meaning of legal texts, statutes, contracts. It often focuses on intent and definition, right? What do these laws mean? While dispute resolution is the process of resolving specific conflicts through litigation, arbitration, or mediation. Interpretation often causes a dispute or resolves a particular dispute. So again, some key differences. Law interpretation works to clarify what a law or contract means. Dispute resolution aims to resolve a problem between two parties. Interpretation is more analytical. It's about legal reasoning and trying to figure out how you get at the meaning of something. While dispute resolution is almost entirely procedural. It's about what is the process by which we solve conflicts between parties. Interpretation often results in a definition or a ruling. So interpretation basically either defines what a law means or makes a ruling on what a law does or does not mean. Dispute resolution is more about a settlement or award or a judgment. Like, you're getting something as a result of dispute resolution. So let's talk about them in a little more detail. So dispute resolution is about figuring out how we solve problems between two parties. Remember, back in the day, if I didn't like you and you didn't like me, we just got our pistols and we dueled in the streets. But we realized that maybe people dueling was not the most appropriate way to solve potential conflicts between parties. So typical methods of dispute resolution, the most common is litigation. So you take someone to court, and that is formal and public, and there are set legal precedents and procedures that one follows when you do that. There's also what we call ADRs, which are alternative dispute resolutions. So this includes arbitration, where a neutral third party gets involved and helps to determine who is correct. There's mediation. That's where a third party just helps the two parties work through their conflict. And there are plea bargains, which is a guilty plea in exchange for lesser charges. So let's say that you are charged with a very serious crime, but the prosecutor or the person accusing you is not sure they can prove it in open court, and you as the defendant or the accused are concerned that if the case goes to court, there's the potential that you'll lose. And so you plea bargain. You agree to plead guilty to a lesser charge in exchange for that guilty plea. Because remember, the easiest way to think about it is, in every court case, you have a plaintiff, so the person who is accusing someone of committing a crime, and the defendant, the person who is being accused of the crime. The plaintiffs, their ultimate goal is to get a guilty plea. That's what they want to do. They want to get you to plead guilty as the accused. And as the accused, you want a not guilty, right? You want the judge or the jury to find you not guilty. Or if you are found guilty, you want the least amount of punishment that you can receive. A plea bargain helps with both of those. A plea bargain gets you a guilty plea as the plaintiff and gets you a reduced punishment as the defendant. So it's sort of the best of both worlds. The challenge is plea bargains often occur in cases where it's basically two parties' word against each other, which means plea bargains are much more common in sexual and violent cases where the only parties involved are the accused and the accuser. It's also really critical to remember that in our system of justice, it is predicated or based on the idea that all people are innocent until they are proven guilty, which means that in our system, sometimes guilty people go free because we would rather a guilty person go free than an innocent person be wrongly punished. When it comes to dispute resolution, there are burdens of proof. Burden of proof is the legal obligation that requires a party to provide evidence to support their claim. So basically, the person doing the accusing has the burden of proof. They have to prove beyond a certain standard that you are guilty. Standards vary from the sort of preponderance of evidence, which is just slightly greater than 50%, to beyond a reasonable doubt, which is you need to be positive that the person being accused committed the crime. So the duty to produce evidence or disprove or prove a fact is on the person who is doing the accusing. All right. So it is not your job as the person accused to prove that you did it. It is the job of the accuser to prove that you did it. So it's not, let me say that again. As the accused, it is not your job to prove that you did not do something, right? It is not your job as someone accused of a crime to prove that you did not commit that crime. It is the job of the person accusing you to prove that you did it, all right? In civil cases, so two parties who are accusing each other of a crime, the burden of proof is typically preponderance of the evidence, meaning it's more likely than not that the accused's claim is true. In a criminal case, prosecution has to prove beyond a reasonable doubt that you committed the crime, meaning that if there has to be almost absolute moral certainty that the person did the thing they're being accused of. So if you think someone did it, but there's doubt in your mind, you should find them not guilty based on the beyond a reasonable doubt standard. The second sort of job of the courts is law interpretation. This is about figuring out what the law means when there is a disagreement about the meaning. So courts try to focus on the intent of parties when they entered into a contract or a rule, right? Contracts are often interpreted as they are written, not how they should have been written. So it doesn't matter if it's a poorly written law or a poorly written contract. It says what it says, and we have to go off of that. Sometimes, like typically, the source of a dispute is when a law is written in a way where the language is vague. So if a law says that the standard is that a reasonable person would agree, well, what defines a reasonable person? If you are entitled to a speedy trial, how do we define what speedy means? Right? You are protected in the Fourth Amendment against unreasonable searches and seizures. But who decides what constitutes unreasonable? How do we figure out what unreasonable means? So law interpretation is all about figuring out those like complicated meanings behind things. It's also important to remember that as we try to figure out meaning, we are somewhat constrained by the fact that the American language as a whole is imprecise. Words don't always mean what it seems like they should mean, right? So sometimes we say things like, we don't use words that are precise. So, for example, the criteria to be president says you have to be at least 35 years old. But the understanding by most political scholars is that at least 35 isn't actually about being 35. That's just an arbitrary number. It's actually about maturity. So the interpretation of what that means for some people is literally 35 is the magic number. And for other people, it's a conversation about you need to be sufficiently mature to be able to do that job. All right, the last thing we're going to talk about is the trial process and who participates in sort of in the process of our trials. So when it comes to sort of our jury system, which is the predominant system that we have in the United States, the U.S. jury process is a civic duty where citizens determine facts in a civil or criminal trial. This is guaranteed by the Constitution. Jurors are randomly selected. They are questioned in a process known as voir dire to ensure impartiality, and they can be challenged by lawyers. Juries hear evidence, receive legal instructions from a judge, and then they make a decision, typically requiring a unanimous verdict, or decision in criminal cases. So the key stages of this process, first it starts with selection, otherwise known as voir dire. Potential jurors are chosen from public records. It could be voter registration, it could be driver's licenses. It varies state to state. During this process, attorneys ask questions to identify bias, and they're allowed to strike for cause, right? So let's say it's a case about a child who was murdered. The defense might want to get parents off the jury, right? Arguing that if it's about a child being murdered, a parent might not be able to be objective about that case. They also are able to do what's called preemptory strikes, which are strikes for no reason. Now, those strikes are not supposed to be used based on racial preferences. So like you are not supposed to be able to strike all of the black jurors or all of the Hispanic jurors or all of the white jurors from a jury. However, lawyers have gotten a little bit more savvy about citing reasons that are sort of cursory or surface level reasons when what they're really trying to get at are those sort of racial undertones to get certain types of people off of a jury. So the jurors hear testimony, view evidence, and are not supposed to discuss the case with anybody outside of the case, and they're not supposed to be discussing the case outside of assigned deliberations by the court. After they've heard everything and they get their instructions from the judge telling them exactly what they're supposed to be considering and the relevant point of law, the jury deliberates in private to reach a verdict. It's either guilty or not guilty in criminal cases, or liable or not liable in civil cases. All right. As a general rule, we have what are known as petite juries or petit juries, depending on who you're listening to. These are trial juries. They're usually 6 to 12 people, almost always an odd number, so it doesn't end in a tie, that determine the outcome of a case. We also have grand juries. Grand juries are juries that determine whether or not there's enough evidence for charges to be brought. So they're not dealing with guilt or innocence. They're just reviewing the facts of the case to see if there's enough evidence there for the case to go to trial. As a general rule, jurors have to be U.S. citizens. They have to be at least 18. They should be proficient in English. You could be disqualified from jury selection if you have a felony conviction, and often active duty military, first responders are exempt. They often exempt students or teachers, people who would have a hard time missing their jobs or being unavailable, to go to school for 2 weeks or a month or however long a trial might take. And their responsibilities are jury duty is mandatory. So if you are summoned for jury duty, you have to respond to that. You're also supposed to be unbiased. There has been considerable focus over the last decade on whether or not people truly have the ability to be unbiased. We're all biased in some manner. For the most part, all we can really do is acknowledge our bias and try to overcome it. And then in terms of compensation, jurors are paid a small fee. Like you get, I think it's like $20 or $25 a day, and then you get paid for food, I believe. So it's not you're not going to get rich off of being a juror, but you are compensated in some way. This is another great video by Vox on jury trials. Again, I will say it every time we watch a video from Vox, they do lean a bit more left than other organizations, but I think they do really good overview videos, which is why I think they do a good job of sort of overviewing the process. The last thing I want you to focus on is judicial philosophy, and this is how judges make decisions. And so there are basically two main buckets that judicial philosophies fall in: activism and restraint. Activism and restraint are sort of opposing philosophies about how a judge interprets the law. Judicial activism says that judges should be an active part of interpreting the Constitution. The argument is that they need to adjust the meaning of the Constitution to deal with current social issues and the protection of rights. The opposite is judicial restraint, which sort of says that judges should limit their own power and discretion, really only getting involved when there's no other choice, and they should adhere to what elected officials want. So when it comes to interpretation, activism uses a broad, sort of more contemporary interpretation of the law. We often call it a living constitution, that the Constitution is moving and morphing and changing, while judicial restraint says we should do what's called strict construction. We should basically interpret the Constitution literally. It says what it says. When it comes to precedent, activist judges are more likely to overturn precedent, arguing that we need to update some laws based on societal changes, where folks who believe in judicial restraint are much more likely to strictly adhere to precedent. Activism is often talked about as legislating from the bench, right? Sort of the critique is that they are making law from the bench and that that's not the job of the courts. Restraint says that the only elected official should make policy. I'm going to argue here, though, that whether you are a activist judge or a judge that believes in constraint, you are still making policy from the bench, right? Like, I think that folks who adhere to judicial restraint have sort of gotten away with making the argument that we're not making law, we're just enforcing existing law. But if society changes and if you uphold a law from 1789 in 2026, you are influencing the law through your inaction, right? Like, you can change the law, you can change society through action, where the court actively plays a role in overturning law, or you can change society through inaction, when you refuse to change something or adjust something. And so I want to make it clear that both activism and restraint are influencing the way that law operates, and both are legislating from the bench. They're just doing it in different ways. All right. So that is an overview of the judicial branch. And I know that was a lot to kind of take in at one time. As always, though, if you have questions, please feel free to jot them down. You could ask them in class. You could shoot me an email, whatever is most effective for you. But I think that provides a pretty good and comprehensive overview of the judicial branch. As always, any questions, please don't hesitate to ask. All right. Have a good one.